My name is Hoey. I studied PPE at Oxford. I graduated in 2015 and I went into a training contract with Ropes & Gray in 2017. I qualified into the finance team. I've been there since, although I've been on client secondment twice at two of our clients, Liberty Global and Morgan Stanley. Between a solicitor and barrister, as someone who did a non-law degree, I was considering various career options and not necessarily just between solicitor and barrister. I did think I wanted to do something in the city, something commercial, potentially finance related, and law was one of the options that appealed to me. So I did a couple of vacation schemes and saw what it was like inside law firms, and I thought that environment was something which suited me. And yeah, in terms of difference between solicitor and barrister, I think it was really the more collaborative side of working as a solicitor that appealed to me, advising clients on transactions and kind of less antagonistic aspects. Like, it never really appealed to me to stand up in court and argue a case. So I was really looking at US firms, and Ropes, like many other US firms at the time and probably still now, had quite a focused offering in terms of transactional work, and Ropes in particular private capital. I knew that I didn't particularly want to do litigation or disputes or kind of other broader advisory areas, so that wasn't an issue for me, and I was applying to similar firms as Ropes with a similar focus in terms of practice areas. People say this all the time, but I think the small trainee intakes was definitely a factor for me. I was only one of 3 trainees at the time, and I was told, yeah, you would get a lot more responsibility and be able to potentially do more challenging work early on because of the small intakes, and I think that really was true at my time as a trainee. So what do I think made my application successful? I mean, this is quite a long time ago now, and I don't think I know for sure, but I know at the time, and Ropes is still a relatively new office. At the time, the office had only been in London for 5 years. We're coming up to our 15th year anniversary now. I think at the time, given the new office, and like they were looking for people with a bit of who could be self-starters, maybe a little bit entrepreneurial, but still, I think in line with other firms, it was really a case of demonstrating that I was sufficiently committed to pursuing a career in law and in the practice areas that Ropes specializes in. So in terms of people applying now to Ropes, I think, yeah, it's equally important to show that you be committed to a career in law and that you have a particular interest in the practice areas that we specialize in. I do think this advice gets given a lot, but I think it's definitely true that if someone's reading your application and they can swap the name of the firm with another similar firm, then it's probably not tailored enough. I think you do want to show to the person reviewing the applications that you've done your research, that you really do know what is distinctive about Ropes versus other firms. When I did my training contract, I did my first seat in private equity transactions, so working on M&A deals and portfolio company work. And then I did my second seat in tax, and third seat, then I went on to finance, and fourth seat I did in private investment funds. So yeah, really quite focused around core of Ropes offering in the US and the UK, which is private capital. One piece of advice that I received as a trainee that still sticks with me now is to always make it easier for whoever's reviewing your work or whoever you're working for. So as you get more senior, that might be the client, but as a trainee or a junior solicitor, your client is really the mid-level associate or maybe the partner, and you want to make it as easy for them to review and input on your work as possible. I think that might be being proactive and offering a solution, or at least having thought about the issue rather than immediately running to someone with a problem. I think that's definitely appreciated. But obviously that does have to be balanced with, you don't want to just be spinning your wheels and not understanding what's going on. One other thing is to always try and read as much as possible if you have the time and understand the wider context of a deal. So as a trainee or a junior, you might just be asked to draft a side letter or make some minor changes to a document. But if there is a reference to another agreement, like the credit agreement, and you should really go look that up and check that reference. It's not always the case that'll be correct, and you kind of want to understand why things are being done and over time build up that knowledge. The typical day for me kind of depends on what stage a deal is at. Obviously it'll be on different matters and different deals might be at different stages. If a deal is in early stages, then you're really trying to understand the commercial context. Maybe there's a tax structure paper, maybe you have to speak to the client and kind of understand what the basics are. And then acting borrower side, typically we'd prepare a grid or a term sheet, which is then circulated to the lenders. And then when you're in the real swing of things, we're negotiating commitment papers or a term sheet or a credit agreement. That's when we're really reviewing and exchanging drafts with counsel on the other side. That is when a lot of issues can come up. The client and the other side might think they have a commercial agreement, but it's really when you put pen to paper and really have to agree the details of various provisions that people might realize they haven't exactly agreed the same thing, or people have different things in mind. So it's really that process of agreeing the legal and technical points with the lawyers, but also highlighting important commercial issues for the client and putting things in a way that is easy to understand for them so they can assess whether to agree to something or not. And then finally, we have the execution stage, kind of as you get to closing or funding a finance transaction, depending on what that deal is. If it's a big M&A deal or a restructuring, either way, there's often lots of parties involved, and we really have to coordinate and make sure that everything is on track for funding and closing. And so that's really the sprint at the end of the deal. So the largest transaction I've worked on over the last 12 months is probably the Altice France restructuring. This is a long-standing finance client of the firm, and it had to restructure its 20 billion of term loans, credit facilities, and bonds. I think it's actually the largest European restructuring to date, and it was a really big deal that involved a lot of teams across Ropes and also lots of other law firms. So it involved our US restructuring team, our UK restructuring team, myself from the English finance team, and also a high-yield bond team, and then also a whole host of other French and Luxembourg law firms. And it's really been quite a long, protracted process to come to an agreement with the creditors and close out the deal. And it's actually something that we're trying to close this week. So the first stage was really negotiating with the creditors in order to cut down the existing debt. And from my role, I was negotiating with one of the many groups of lenders. Then we agreed a lockup agreement, which is an agreement in principle with the lenders. And then the whole process was kind of put to French restructuring lawyers because it had to be approved by the French courts. And then after the French courts approved the deal, then we put in place the new financing. So then we're really involved in the kind of execution mode, as I mentioned. We're documenting all of the new agreements going forward and ensuring that all of the conditions to the restructuring are met for closing. I think the most challenging aspects as a lawyer, especially on the transactional side and working for firms which want to operate at the top of the market, is that our clients need us to be responsive. So it's really about being available and reactive at all times, and that goes all the way up from partners being always available to pick up the phone, but also then if you're a junior, then you do need to be available when needed. As you get more senior, you do get more visibility and things will get busy, but it can be hard to make plans if you don't know whether something's going to, like a deal is going to kick off in a serious way. But I think what is rewarding is getting outcomes for clients that they're really happy with. That's always the most rewarding aspect, when you get good feedback and everyone is really happy with both the work that you've put in over what can sometimes be a few months or even longer. And obviously it can be nice when you see yourself having worked on a large deal and it's reported in the financial press and something that's really significant for the company or the client. Personally, I also get satisfaction from the technical side of the job. So, some of the documents are quite complex, and it is intellectually rewarding as well to kind of agree complex provisions in these documents that will be in place for quite a long time and be relevant for a long time. In terms of business development, I think Ropes is actually very good at encouraging associates to do business development and participate in business development. So if we ever have any ideas for events that clients might like, or clients might actually suggest things they want to do. So for example, I've taken clients to the rugby, to the cricket. We did Taylor Swift last year, which was very popular. So it's really, if you have an idea, then you can just take it to the partners, and they rarely say no unless the budget is very unreasonable. But I think there's a real focus on developing client relationships early, so that as you progress and get more senior, the people that you have connections with at the client also getting more senior at the same time. So yeah, there's a real emphasis on participating in business development from an early stage. In terms of work-life balance, as I mentioned, you often get execution mode and closing, and that can be on quite short timelines, so people are under pressure to get things done, and that can mean late nights, but it is quite up and down as well. So I think after a big closing or you close a big deal, there can be a week or a couple of weeks where things are a bit slower. If you're in the kind of negotiation stretch and people are exchanging drafts, then it can be a bit less urgent, a bit more time to do things. I would say kind of late nights are unfortunately part of what we do, but weekends I think is a little bit rarer. We do have to work weekends sometimes, but I'd say it's kind of really when you're coming up to a big closing and everything needs to be done on an urgent time frame. I wouldn't say I have to work most weekends. Yeah, in terms of the life balance part, I have time to do cycling and running, and I try and balance that around work. Sometimes that might mean running into the office or running home from the office to save time, but yeah, I think it's part of juggling work, but I would say, yeah, for the most part, I do get my weekends free. So in terms of working with other teams in the office, I'd say the two teams we work the most with are the restructuring team, like on the Altice France deal that I just mentioned, and also with the PE M&A team. So in terms of the latter, that would be supporting them on a leveraged buyout for one of our PE sponsor clients. So ideally, we'd get both the mandate to work on the corporate acquisition and also the financing side, in which case we'll be working together. And also, we might support them in the diligence phase. If the sponsor is looking at acquiring a target, then we diligence the existing finance documents to see if there's any issues. On the flip side, if we're acting for the lenders for an M&A bid, then we'll get a copy of the SPA, the share purchase agreement, and we'll ask the M&A team to review and summarize that for us. So yeah, there's quite a lot of cooperation between the two teams. And I guess the last team that we work with probably the most is the tax team. As you'd expect in a lot of these transactions, tax is a very important aspect, and we do need to get tax advice. As a trainee, I think actually there was quite a lot of client communication. I think the most common would be, as you're closing a deal, you really have to coordinate and liaise with the client to get information from the client, coordinating signing of pages. I think probably the most nerve-wracking as a trainee was having to run directors through board minutes. So often for a finance deal, the company has to approve the transaction, and there'll be a set of minutes that we prepare. And on a few occasions, as the trainee, we'd be asked to run a call and just walk the directors through what's being approved, and they may have questions on the documents and why this document is being included, or the kind of key terms. So yeah, that was probably one of the more nerve-wracking things I had to do as a trainee. But yeah, I think in general, because of the small teams, it's not really practical for even junior members of the team to be dealing with everything with the client. So, as a trainee, you do get to have some contact with the client.